Hi, welcome to the first panel, Police Powers and the Pandemic. I'm the moderator, John Harrison, University of Virginia School of Law. Today is a big day for the single-digit titles of the United States Code. As we speak, 3 U.S.C. 15 is getting its quadrennial moment in the sun. It's the Electoral Count Act. 2 U.S.C. 27 is also related to our topic. It provides whenever Congress is about to convene, and from the prevalence of contagious sickness or the existence of other circumstances, it would, in the opinion of the president, be hazardous to the lives or health of the members to meet at the seat of government. The president is authorized by proclamation to convene Congress at such other place as he may judge proper. 2 U.S.C. 27 is the result of the 1793 yellow fever outbreak in Philadelphia, which caused heavy loss of life and caused the government, in effect, to shut down. So our topic is not a new one. We have an excellent set of panelists. I'll just identify them very briefly, and then they'll start talking with us. Julia Mahoney, here at the University of Virginia School of Law. Then we'll hear from Dan Rodriguez of the Pritzker School of Law at Northwestern. Then David Bernstein at the Antonin Scalia School of Law at George Mason. And finally, Ilan Wurman at the Sandra Day O'Connor School of Law at Arizona State. Julia?
Thank you. Thank you, John. I am very excited to be here, and I very much look forward to the panel discussion and to the audience questions and comments. I'm going to start in the late 18th century with the centrality of the idea of the people's welfare to the Republican ideology of the Revolutionary and founding eras, and what this meant as a practical matter for the first decades of the United States. And then I'll move on to the late 19th century, to the early 20th century, to the so-called New Deal settlement, and finally discuss what all this means for us struggling with questions of the contours of government power when it comes to infectious disease in the early 21st century. So back to the late 18th century, to the new American Republic. As Gordon Wood puts it in his book, The Creation of the American Republic, to make the people's welfare, the public good, the exclusive end of government, became for Americans their polar star, the central tenet of the Whig faith. But what did this mean for the new nation when it again and again and again confronted the old problem of infectious disease? Because as Professor Harrison just averred, infectious disease was very much with the United States in its early decades. The 1793 yellow fever outbreak in Philadelphia was especially virulent and deadly, but there were many others. And yellow fever was not the only scourge. Smallpox was, of course, not tamed until the 20th century. And as United States history wore on, yellow fever and smallpox were joined by cholera, polio, numerous other maladies. And it was a key part of the job of the government, with state and local governments, of course, taking the lead, to protect the public health and well-being to the best of their ability. And the exercise of government power to attempt to blunt the devastating effects of these infectious diseases was not a matter of controversy in the early republic. However, the exercise of the powers was not without complication. And there are two things that I would like to flag, two issues that I believe are of particular relevance as we confront what government powers, what powers government should have in the early 21st century. The first issue I want to flag is that of transparency of whether the government is doing a good job. Thinking about the early decades of the American Republic, the problems that government confronted were familiar ones. The diseases, just for starters, were not new, or to the extent that they seemed to be new, they were not in effect something where there were the huge questions about what it is that governments ought to be doing. It might be that the government wasn't necessarily right in terms of what it ought to be doing, but there wasn't an enormous division of popular opinion in terms of what might be a good idea or a bad idea. In other words, government was more transparent and accountable, so far as we can tell, than has been, I think, at least the case during this COVID-19 pandemic. Second issue that I think deserves at least glancing attention from us before I move on to later periods in US history is that of the detrimental effects on Americans from government actions to control infectious disease, which did not, as John Witt of Yale and a number of other scholars have documented, did not fall evenly on the population. The law, says John Witt has argued in his recent book, American Contagions, the law has protected property rights for the wealthy and attended to the civil liberties of the powerful. But for the disadvantaged in the United States, government action to control infectious disease has very often been arbitrary and authoritarian. John Witt and others have contrasted the quarantinist approach, which was often something that the poorer were subject or the less politically powerful were subject to, with a more sanitationist approach, which has tended to be, very, very roughly speaking, the fate of those who were better connected and perhaps richer. And so when we ponder what kind of regimes we want in the early 21st century, I think it makes sense to at least bear in mind that what the government was doing with respect to infectious disease in the late 18th century and early 19th century was hardly any kind of paradise, hardly something that we should necessarily want to return to. Put simply, I think we may be able to do a bit better. But let me move on. Let me move on to after the Civil War, when the questions of contours of the police power became extremely fraught. Government began to regulate more aggressively. As John Compton has noted in his wonderful book, The Evangelical Origins of the Living Constitution, the Great Awakening and other aspects of religious revival meant that government was eager to regulate. State and local governments were often eager to regulate lifestyle things that those of the founding generation had seen no reason to try to rein in. Result, many controversies about the police power, particularly with respect to matters of public health and morals, such as pool halls and alcohol and gambling, and so on and so forth. There's still the question of infectious disease and what precisely government could do and not do. In 1905, the Supreme Court handed down what is still probably the most famous precedent with respect to infectious disease, Jacobson v. Massachusetts, which sustained the constitutionality of an ordinance that provided for a fine, not for mandatory vaccination, but for a fine of $5 for someone who refused to take the vaccination. This question of police power continued to rage in the early 20th century. Exactly how far could government regulation go? In 1926, Justice Sutherland, sustaining the constitutionality of a comprehensive zoning ordinance, meditated on the contours of the police power, but not in a way that I think any readers have ever found terribly satisfactory. The ordinance now under review and all similar laws and regulations must find their justification in some aspect of the police power asserted for the public welfare. But how are we to figure out where the police power ends? Justice Sutherland tells us that nuisance law furnishes us a helpful clue and so forth. He suggests that what is permissible changes over time with technological innovations, but we're pretty much left high and dry. And so it does not come as a massive surprise that when the Supreme Court in the New Deal era begins to think about what it is going to do in terms of ordinary social and economic legislation, it can't think of much to do except to withdraw largely from the field, to, in effect, allow for expansions of police power, and to say, although the Supreme Court, of course, didn't exactly execute this the way that it said it was going to do, to say that courts were going to pretty much get out of the business of reviewing acts of the legislature, at least ones pertaining to ordinary social and economic legislation, for constitutionality, and that those who thought the government had perhaps exceeded its police powers or exceeded what its police powers should do, could bring their beefs to the legislature with, of course, some very important carve-outs, most importantly, the First Amendment. So This, of course, has set up a world where when COVID-19 hits, we don't have very well-developed frameworks, or so I would argue, for assessing the permissibility of government action. We have perhaps a system whereby the government can do pretty much anything because the police powers are without clearly articulated limit, unless that government action bumps up against some recognized constitutional right. That may, of course, be completely wrong. It may be that the court made a mistake back in the New Deal era not to at least try to devise, not to at least try to articulate some kind of doctrinal limits on the exercise of the police power. If one takes seriously the problem raised by John Witt and others, that throughout American history, the poorer and less politically powerful have tended to suffer a lot more when government acts, particularly quickly and strongly, to rein in infectious disease. Well, then we might look at the New Deal settlement crafted as a lost opportunity. But what does this mean for us today in the early 21st century? How should we proceed? I would argue, and I hope to be able to say more about this as our discussion unfolds, that as a starting point, we should distinguish between ex ante and ex post. In other words, we should think very carefully about the practical limits of the ability of courts, particularly as a prudential matter, to stop, to halt government actions that are billed as preventing infectious disease. That is not to say that courts have no role in terms of enjoining the enforcement of government actions, but simply to recognize that as a matter that realistically, courts are going to take a less aggressive role, may hesitate. But that brings me to the second issue, to the ex post. After the dust has settled, I think that we should give very serious consideration to compensating those who have suffered particular injuries, either through the takings clause, through awarding damages for violations of due process, or when legislative action is taken, being sure that the money spent includes compensation for those who have had their livelihoods or businesses. Anyway, I've run out of time, so I hope to pick up on these themes later.
Thank you, Julia. Dan?
So let me first thank you and thank the Federalist Society, and particularly my good friend Lili Romanotis for reaching out to me and including me in this panel. I'm pleased and privileged to be able to do so. So I won't offer, as John and Julia did, the perspective of history, unless by history we mean way back in March of 2020. So I'll focus on police power in connection with the pandemic, particularly, as I know all of our panelists will. So let me begin with an observation, and that is an assessment of the exercise of governmental power under the police power over the last, what is it, 10 months approximately, has been defined, and indeed ought to be defined, by the exercise of power by the government, that is what it has done, but also what it hasn't done. And the law provides precious little guidance, right, for providing responsibilities imposed on government for what it hasn't done. And I want to raise at a couple different junctures questions about why that is a problem. So these are assessments not only at the level of public policy, but assessments, which is germane to our panel in particular, at the level of law, and in particular constitutional law, to some extent administrative law as well. A couple things to say, three things, again, by way of introduction. Number one is police power, maybe this is an obvious point, is a crucial power. It obviously, as Julia notes in connection with her quotation of Gordon Wood, it's part of the essential conduct and function of government. And so when we talk about the police power defined as the power to regulate health, safety, and welfare, we're really focusing in on the ends of government, what gives the government the authority to act in the people's name altogether. It's the principal end of government. The other reason why the police power under state constitutionalism is so critical is because of the absence of a national police power. It's the dearth, it's the reserve power to the states that makes the police power exercised by state government so very crucial. Police power has always been subject to constraints, not only constraints at the level of constitutional rights, what was central to the history that Julia reports and that was mentioned crucially in the Jacobson case, but they're constraints by way of reasonableness. It's It's not an unlimited power. It was never intended to be unlimited power. The history does not suggest it is such. It's not, as it were, kind of a mini 10th Amendment in which the state governments are given all of the powers to act, even in the absence of state constitutional authority. It's also, though, crucially been subject to the constraints imposed by constitutional rights. So we know that under the police power, whether the governor is acting or the legislature is acting or administrative agencies, they cannot engage in excessive restraints on individual rights and liberties. That is, as an aside, particularly important in the state constitutional context, which, unlike the federal constitution, has and has long had a robust, more or less robust conception of economic liberties. The lines drawn should be non-discriminatory, which is not to say that there cannot be distinctions drawn, of course, but if there are distinctions drawn between, for example, essential or non-essential businesses, between religious worship and other gatherings, they must be defensible and defended on some grounds of reasonableness that are evidence-based. As I mentioned before, the law does not provide a very workable mechanism for compelling governmental action, which leaves a gap indeed. 3 points I want to make. One, first about Jacobson, and I want to put it under the rubric of a bumper sticker, and that is Jacobson's suspension is not a real thing. It's a red herring. The notion that the Jacobson decision at the beginning of the 20th century stands for the proposition that in times of public health emergency, the Constitution doesn't apply, has never been our constitutional law. It's never been our police power law. It wasn't the law under Munn. It wasn't the law in the early public health cases. It wasn't part and parcel of what Jacobson says. So when Justice Gorsuch says in the Roman Diocese opinion, the Constitution, eloquently, as he's wont to do, that the Constitution is not here to take a sabbatical in the time of public health emergencies, the modal response should be, duh. Of course, that's right. Public health authority and the police power is subject to constitutional limits. The question is how deferential courts should or should not be in the context of the invocation of civil liberties in times of public health emergency. I want to call an audible here just briefly and respond to something that Julia said and maybe foment at least a mild disagreement. When she suggests that the courts in the post-New Deal period withdrew from intervention under the name of the police power in order to concede or in essence to concede the very broad swath of governmental power, I think there's if I may, a key piece missing, which is true enough. The courts seldom, state courts in particular, invoked constraints, constitutional-based constraints on the exercise of state governmental authority under the rubric of the police power on the one hand. But let's be clear that in the period of time from the New Deal to the present, we witnessed an enormous expansion of constitutional rights and liberties. This was the era of the incorporation doctrine. This was the era of broader interpretations of the First Amendment, free speech, freedom of assembly, freedom of religion, and all of that. So the courts didn't need to invoke a more narrow conception of the police power in order to protect individuals against governmental action. I just want to suggest it's the yin and the yang of the scope of governmental authority, but also the scope of constitutional rights and constitutional liberties that were really at stake. Second point I want to make, and this I know will feed into where I suspect Ilan will go in his comments, which I'm looking forward to, is that the police power is necessarily subject to various procedural constraints, irrespective of constitutional rights and liberties. Always has, hopefully always will be, certainly should. Those come under the rubric of separation of powers, where the key questions involve who gets to exercise the police power and under what conditions and constraints. State administrative law has a lot to say, and it has during the pandemic on the scope of exercise of police power. Indeed, the Wisconsin case, which struck down the exercise of police power authority way back in May, seems like ancient history, was largely decided on fairly conventional administrative law grounds. Conventional by which I don't mean uncontroversial, but grounds that have to do with administrative law. The invocation of the non-delegation doctrine as constraints. We can agree to disagree, or I should say I disagree with what the Michigan court said and what Ilan argues that the Arizona Supreme Court should say in terms of the invocation of the non-delegation doctrine. But I want to be clear in saying that it seems quite appropriate and quite proper for the non-delegation doctrine to exist as a constitutional constraint under proper circumstances on the exercise of the police power. And lastly, what I want to say is that the police power yields on the whole inadequate tools for the exercise of governmental authority. This is where I come back again to the point where the state constitutional law does not provide an enormous basis for compelling the government to act. The government hasn't enforced many of the requirements under the pandemic, notwithstanding the controversy over the exercise of its power. Many folks don't comply. The resources are limited to provide support for businesses and individuals, as Julia notes, who are coping with the pandemic. So at the end of the day, one of the lessons of the police power, normative lessons of the police power, is it's not only a set of empowerments given to the government to act. It ought to be part and parcel of a set of responsibilities, constitutional responsibilities and legal responsibilities imposed on the government to exercise all of the authority necessary to not only arrest the contagion of the pandemic, but also to provide the kind of social services and governmental services that will enable folks to thrive and prosper during the most severe aspects of what they're experiencing. Thanks.
Thank you, Dan. David?
Yeah, hi. So thanks for inviting me. Wish to see you in person next year. Let me start with a few basic points about the police power. First, the origin and historical scope of the whole concept of the police power as the font of government authority is pretty vague and has received a lot less attention than it should. About once a year, I get a call or an email from a colleague who's working on a constitutional law project or a legal history project. They say, hey, David, you're the big Lochner expert. Lochner was a big police power case. Could you refer me to the leading literature explaining where this concept of the police power came from and how it came to be so important in constitutional law? And I always have to respond that I don't know, that I thought that this is such an important aspect of constitutional history that when I was writing my Lochner book, Rehabilitating Lochner, that surely I would come across a lot of secondary sources, if not modern ones, at least 19th century sources that would explain this to me. But it turns out that this was just kind of accepted as a thing that was out there without a lot of explanation. So if you're an originalist, you're going to have a hard time getting a good grip on exactly what the scope of the police power is from an originalist perspective, because there's so little history of the police power that's really been written that it's really very difficult to get a good grasp on. I'm glad to see that some of my younger colleagues like Ilan and Evan Bernick and others are starting to address this, but for now we're still a little bit bereft of a really broad literature that we can rely on. Second, as has already been discussed a bit, the scope of the police power has always been kind of vague. The traditional formulation is the power to promote public health, safety, and morals. Sometimes people who wanted a broader police power would add general welfare, so the power to promote public health, safety, morals, and general welfare, which makes it really broad and really vague. And precisely because of this vagueness, courts were typically deferential to claimed exercises of the police power by state governments and local governments, so long as the legislation in question didn't seem arbitrary. As Dan mentioned, it couldn't be discriminatory. It couldn't clearly favor or disfavor particular groups for no valid reason. And it also couldn't invade an important right without reasonable justification. Finally, the concept of police powers as dictating the scope of constitutional state action, as Julia mentioned and Dan addressed, basically died out after the New Deal, at least in the Supreme Court, because it was really perceived as a relic of the old order that no one really understood anymore or wanted to go back to. It was replaced with tiers of scrutiny, state interests, and the like. So I think both Julia is right that it kind of died out, and Dan is right that this didn't give the government carte blanche. It was replaced with other things. But the police power has made a big comeback, starting a little bit in the 1990s, but even more so recently, partly because we have more conservatives on the courts who are interested in originalism and do not, blanch at looking back at 19th century and early 20th century precedent as at least being informative of some of the issues. But I think also because we've had a conservative Supreme Court that has not been willing to expand the scope of fundamental rights or of equal protection strict scrutiny categories. So we haven't had a new strict scrutiny category for equal protection for over 30, maybe 40, over 40 years. We haven't had a new fundamental right since the 70s, I don't think. So a lot of new issues come up, and saying that everything has to be either rational basis, almost no review, or strict scrutiny, and we're not willing to strictly scrutinize much, leaves maybe too much scope for government authority. So it's really becoming more of a contemporary issue. So this panel is really very timely. With that said, let's talk a little bit about the pandemic. Public health and safety are classic police power functions. And I think there's no doubt that the government has the authority to take even extreme measures to stop the spread of infectious diseases. And not only for people, the Supreme Court even held unanimously in the 1920s that you could burn down someone's orchard to stop the spread of agricultural disease or other or fires or anything else, and you don't have to give any compensation. So here you have a court that was, fairly sympathetic to property rights, saying you don't even need compensation to destroy someone's entire livelihood for the public benefit. But all that said, it doesn't resolve two questions. First, who has the relevant authority, the governor or the state legislature, to set the parameters of the relevant public health measures under the police power? And second, how deferential should the courts be when plaintiffs make the case that they are arbitrary in the two senses that we mentioned earlier? I know Ilan is going to talk more about delegation of power to the executive from an originalist perspective, but I'll assert here that regardless of originalism, and no matter how much of an originalist you may be, if you're a judge sitting on the court in a public health emergency, assuming the legislature has delegated some authority to the governor, and even if it hasn't, the idea that you're going to wait for the legislature to come back, I mean, maybe now today this is plausible, but the 19th century, let's say there was a big cholera epidemic in New Orleans, which there was every decade or so. And it so happens the legislature had just stopped convening for the year, and everyone's gone off to the various towns, cities, and bayous of Louisiana. And, it's going to take weeks just to get messages out to the various parts of Louisiana to try to get the state legislatures back into session to have a quorum. And it'll take even longer to debate the legislation. And meanwhile, what's the governor going to do? Say, well, sorry, I know that the legislature delegated me authority, but I'm just going to let people die of cholera meanwhile. And anyway, the courts wouldn't let me do it. And the governor says, well, maybe I should do something anyway. And the courts say, no, we're going to let thousands of people die of cholera while we wait for the horses and buggies to come in from Baton Rouge. Not going to happen, right? So there's going to be some emergency authority, especially if it's been delegated. That said, you could argue that the legislature should make specific rules in advance, and they should, but without knowing the scope, origins, and contours of any given emergency, it would be very difficult for the governor to be constrained by that if some kind of unexpected emergency like COVID that no one was anticipating suddenly comes up. Broad delegations of emergency powers, though, put a lot of potentially dictatorial power in the hands of the executive. So while at the beginning of an emergency, I think courts are rightly inclined to defer to the executive. Initial emergency measures, when we have limited information and we're in a rush, are likely to be imprecise. But courts can't abdicate entirely. I mean, imagine, I know this is a real counterfactual here, that's going to be difficult to imagine, but imagine having a powerful executive official who is immature, vindictive, and primarily looking out for his own self-interest. Now imagine that somehow, someday, someone like that manages to achieve executive office. He could use his emergency powers to reward friends and punish enemies in legally arbitrary ways, and courts really need to be able to police that. Moreover, even a less mendacious executive may have unconstitutional notions about what things to prioritize. So we've seen this during the pandemic, that we allow mass Black Lives Matters rallies because the politicians are sympathetic to those rallies, but they don't allow outdoor funeral services that have more than 10 mourners. Now, Bill de Blasio or whoever may think that Black Lives Matter is more important than being able to say a prayer at your mother's gravesite or whatever, but there's no constitutional basis for allowing that distinction to be made. Some rules that were implemented in some states were just absurdly arbitrary. In Michigan, you were allowed to walk on the golf course, but not play golf. You weren't allowed to carry golf clubs with you. Kayaks and sailboats were allowed, but not small motorboats. Landscapers were allowed to work, assumingly because they work outdoors, but not roofers who also work outdoors. Auto repair shops were allowed, but not bike repair, and so forth. Again, one might forgive such imprecision when there's a rush to get the orders out there. But if they persist, courts are absolutely justified in not, for example, allowing roofers' livelihoods to be destroyed arbitrarily. More generally, emergency executive rules are less likely to have undergone public debate and the give and take of various interest groups than legislation addressing the same matters. So while courts probably should be inclined to be deferential at the beginning of an emergency, the longer the legislature fails to act and the longer the executive is ruling by decree, and let's face it, it's been in some states already almost a year where we're being ruled by executive decree, the less deferential courts should be. After all, there is a fine line between short-lived emergency measures and living under autocracy. Thank you.
Thank you, David. Ilan?
Thanks so much for having me here on this terrific panel. In my 8 minutes, I'd like to do 3 things. First, I'll summarize briefly some research on the police powers that I've done in the antebellum period, and then I'll describe how the police powers are still relevant today in 2 areas related to the coronavirus pandemic. The first has to do with delegations of police powers to governors, as has been anticipated already by my co-panelists. And the second has to do with enforcement of state privileges or immunities clauses, and potentially eventually even the federal privileges or immunities clause, which I think does similar work. So regarding my prior research into this, and David also alluded to this a bit, I have a paper in the University of Chicago Law Review called The Origins of Substantive Due Process, where I examine these antebellum police power cases. And what I sort of discovered there was that they don't actually stand for the proposition for which they're ordinarily thought to stand. I argue, in short, that there was no substantive due process in antebellum law. There was no general police power limit on state legislatures. There theoretically was, but it was understood to be entirely within the legislative wisdom what was a proper exercise of that power. So call it the antebellum rational basis test, if you will. There were, however, a variety of police power doctrines, judicially enforceable ones. The most prominent had to do with delegations of authority to municipal corporations. When the legislature delegated power to municipal corporations, the judicial courts did police their exercises of power to ensure reasonableness, that they were not in restraint of trade, that was a phrase we heard a lot, and that they were genuinely for police power purposes. The idea here was their authority was limited to those powers expressly delegated by the legislatures or necessarily implied. So if the municipal corporation, the city or the town, was exercising power pursuant to a broader delegation of authority, the courts then did review their acts to ensure reasonableness and that they were legitimate exercises of the police power on the theory that the legislature would not have intended to delegate the power to act unreasonably. I'm simplifying a bit. There's also this common law of corporations out there that was applied. But simply put, if the legislature did expressly delegate the power to do unreasonable things, then municipal corporations were allowed to do those unreasonable things. So that's municipal corporations. There were then two other doctrines, where the state legislature itself was in fact limited only to reasonable exercises of the police power. But these 2 other doctrines were quite narrow. This was where state power came into potential collision with explicit federal constitutional prohibitions. One was the Commerce Clause, which was assumed in the antebellum period to be exclusive. So whenever a state regulation affected interstate commerce, say a quarantine law, the federal courts would uphold the state regulation if it was a genuine and frank exercise of the state's police power. If it was such a regulation, then the court would deem it a regulation of police, which was permissible, of course, to the states, rather than a regulation of interstate commerce, which was assumed to be prohibited to the states. And a similar doctrine existed for the Contracts Clause. So what does this have to teach us about the police powers today in the COVID-19 pandemic? 2 things, starting with delegation. Here in Arizona, we have a statute that delegates to the governor all police power of the state in event of an emergency. Putting aside the non-delegation doctrine, which I raised in the lawsuit that I think Dan alluded to on behalf of bar owners across the state. I'm representing them now in the Arizona Supreme Court here. For present purposes, my point is a bit different. I argue that if the police powers are delegated to the executive does not get the benefit of the rational basis test. Only the legislature gets the benefit of that test. The executive is more like a municipal corporation. The courts, in other words, it is exercising delegated power delegated by the legislature. The courts should therefore rigorously ensure that the executive is complying with the delegation. And surely, again, the legislature did not intend the executive to act unreasonably, just like it doesn't intend municipal corporations to act unreasonably. So it is for the courts, in other words, as I argue, to ensure the reasonableness of executive actions made pursuant to broad delegations of police power authority. So again, in short, the legislature may get the benefit of the rational basis test, but no principle of law of which I am aware says that the executive should also get such deference. The second implication is for discrimination claims under state privileges or immunities clause, and perhaps one day under the federal privileges or immunities clause, which I argue in a new book is an anti-discrimination provision, much like John Harrison argued in the 1990s. My findings from the antebellum research, in other words, suggest that there was no substantive due process. Lochner, I do think, was wrongly decided. It was for the legislature to decide the wisdom of the maximum hour laws for bakers. But that doesn't mean that slaughterhouse was rightly decided. In Lochner, we had a regulation. In slaughterhouse, there was a discrimination. Similarly situated citizens were treated differently by the grant of a slaughterhouse monopoly to a group of favored butchers. I argue that the privileges or immunities clause does require a police powers analysis when there is an alleged discrimination, such as in that case, or as in my case here in Arizona, where the government allowed breweries, hotel bars, restaurant bars, and private clubs all to stay open and operating while scapegoating a small number of other bars with different license numbers. If there is a discrimination, in other words, it must be justified by a legitimate and valid exercise of the police power. Otherwise, it comes into collision with an express constitutional prohibition on abridging the privileges and immunities of citizens, which is just as express a prohibition as the prohibition on regulating interstate commerce or impaired contractual obligations in the antebellum period, and it's just as express as modern day First Amendment prohibitions or other Bill of Rights prohibitions. So one might say in summary, the rational basis test only applies to actions of the state legislatures and only to substantive due process claims, only to unwritten constitutional limits. It does not apply, or it should not apply, to other government actors exercising delegated police powers or where those police powers come into potential conflict with express constitutional prohibitions. I see I have actually another minute, so I timed this even better than I thought. So I will mention the non-delegation doctrine after all, since both Professor Harrison and Rodriguez mentioned it. So let me just briefly state my position on that issue, since it's also here raised in the lawsuit. As I mentioned, Arizona has a statute that delegates all police power to the governor. Well, in our brief that we filed today in the Arizona Supreme Court, what we actually argue is that the legislature can delegate authority to regulate private rights and conduct, not just in a pandemic, but at any time. But we argue that three conditions must be met. We argue first that the authorization must be made expressly. It can't be hidden in a delegation of power to regulate in the public interest or in a delegation of all police power. Second, the category of conduct, we argue, must be narrow. It can't be this roving commission over all sorts of human behavior. That's also a problem with the Arizona statute. And finally, perhaps unsurprisingly, we argue that the standards have to be more precise when the legislature authorizes, than when the legislature authorizes the regulation of official conduct. Okay, so now I'm really at my time. So just in summary, my claims are that there is no substantive due process, sort of an antebellum law, and substantive due process in the Lochner era was likely a mistake, but the police powers should still play a role in several parts of modern law, including parts of modern law related to the coronavirus pandemic, the law of delegation, the law of discrimination, and maybe even tangentially the law of non-delegation. Thank you.
Thank you, Ilan. What I'd like to do now is get some interchange among our panelists. In a moment, I'm going to ask if anybody has any thoughts they want to give us about what anybody else has said. Let me suggest a couple of issues. The first one goes back to the 19th century and sort of into the first half of the 20th century, when a lot of the kind of doctrines in which the police power figured were about the protection, especially of property rights, from redistribution. One of the things that all the panelists have touched on is the possibility of the use of the kinds of emergency powers we're talking about to favor some groups at the expense of others, which was always a big problem for sort of the older doctrine in which the police power was so important. So my first question is, and again, anything else, but I do want to pose this. First question is, today, how much of the problem of sort of governmental error is about favoritism, arbitrary distinctions among groups, and how much of it is about just maybe the government has overreacted and has unduly restricted the activities of everybody? So which kind of problem is it? The other thing I'd be interested in hearing anybody has a thought on is the federalism aspect of this problem. And either as a constitutional matter or as a matter of sound policy, what is the best role for the states? What's the proper role for the national government? So I want to get those two thoughts in there. And again, I'll just start with Julia. We'll go through in the order in which everybody spoke. If you have any thoughts about what anybody else said or what I just asked about.
Yes, indeed. So let me first make it clear that Dan and I think, pretty much agree on 90%, but the 10% we disagree on, I suspect, is terribly important. Of course, the quote, New Deal settlement didn't lead to courts withdrawing from the field. I think I made that clear, that it didn't work out that way. Even at the time of the quote, New Deal settlement, the Supreme Court was clear that the First Amendment was special. And so the big question, or one of the big questions that we confront now is, do we have a regime where police powers are pretty much not limited and the only limits are in other various constitutional rights, et cetera, that we can identify? Or are there actually some limits on the police power, full stop? Dan seemed to be suggesting that it didn't really matter because I don't mean to put words in his mouth, but that we may have gotten to pretty much the same place, albeit by different routes. And that's the part where I think Dan and I probably disagree, because I look at constitutional litigation right now, particularly during the COVID-19 crisis, and see that it is much, much, much better for litigants to be able to shoehorn their claims into the First Amendment or some kind of other area where there is a body of doctrine, as opposed to simply trying to convince a court that the government has overstepped its bounds in a vague way. Addressing one of John's points, you raised the issue of redistribution and asked if we should distinguish the problem of redistribution and favoritism and cronyism, which, as you point out, have been perennial issues throughout United States history, whether we should in some way distinguish that from simply government overreacting and doing stuff that might be the product of emotional upset and hysteria and so on, but stuff that pretty much hits everyone equally. I think the difficulty is that there's not a clear line between those two sorts of government action. It's inevitably, I think, going to be the case that even where government is not trying to help some at the expense of others, governments are often going to be much more aware of the detrimental effects of their even their non-facially discriminatory actions on some than others. So exactly how we craft doctrines that will address that, that I think is difficult.
Dan?
Sure. So I'll jump in. Thank you, Julia, for engaging on that. I think you've exactly focused in on some amount of disagreement. So let me take a second whack at this. The problem with respect to use your term, shoehorning the issue into an existing constitutional rubric, from the vantage point here, I'm going to probably be to the right of everyone in this panel, which is an amazing statement. The problem with shoehorning that is there is not a rubric post-Lochner that provides very much under federal constitutional law for protection of economic liberties for individuals who are complaining their economic interests are being formed outside of the context of discrimination, right? Because rational basis doesn't do much effort. So we don't have an area of litigation for the gym owner who's completely put out of business, or the bars are put completely out of business. The most they can invoke is, hey, why are you picking on us so much? Now, maybe Ilan wins in his litigation in Arizona, and 47 of the other states. Michigan already is on that ledger, and so there are procedural protections. But unless we have a rubric for constraining the exercise of police power authority independent of the constitutional right, there are going to be some difficulties for certain kinds of claims. Very quickly, a very particular question for Ilan. I'm at a complete disadvantage with respect to the history of the Privileges and Immunities Clause and almost everything else. I'm at less of a disadvantage about municipal corporation laws because I know a little bit something like this. So let me take a run at this. One of the reasons why municipal corporations might have had such little valence with respect to protections was, even though it was before Hunter versus Pittsburgh, it was still this idea of municipal corporations as creatures of the state government. So they existed in a very different domain than governors did vis-a-vis the power of the legislature. That, of course, changed in important ways, not comprehensive ways, but important ways with the arrival of the home rule movement. So now in home rule states, you can make an argument that cities, municipalities have some constitutional status, not the same as governors, but exist alongside other engines of government. So I wonder if your point about municipal corporations, kind of pre-Thomas Cooley and all of that stuff, is more of an anachronism than meets the eye. And very quickly to David, I just sort of would ask this question. I really, it's very interesting, your point about the continuation of the decree, right, over some period of time. But I have to ask this, now here we are in January, where we are, to use a legal term of art, totally screwed, right, in terms of the continuation of the pandemic. So the legislatures, by and large, with some exceptions, have sat idly by now for 10 months. Unless you believe that they simply were betting on the curve being flattened or the virus going away like the flu, they haven't really intervened to do very much of anything, to provide limitations on the governors, to provide a criteria, to engage more actively. So what you call government by decree, I'm saying thank God for the governors being able to at least have some emergency authority to deal with the S storm that we're facing in most of our states right now. What do you think of that? Question mark. What do you think of that?
Thanks, Dan. David?
Yeah, that's a really good point, Dan. And the solution cannot be, on the one hand, for the courts to say, well, the legislature hasn't gotten involved, so we're just going to strike everything down and let there be pandemonium and terrible public health consequences. I do think that maybe as time has developed, the plaintiffs can now show more on a factual basis how things are working or not working. Courts might be more sensitive, but it does raise, I think it raises a much broader problem of the current constitutional epoch that we're in, which is that legislatures, and this especially applies to Congress as well, don't want to legislate, right? So the executive branch has been getting more and more power at the federal level, but in part that's because Congress refuses to legislate, or when they do legislate, they write these vague, broad laws. So Trump comes in and says, well, I want to interpret this law, environmental law, narrowly, and I'm sure Biden will come in and interpret it more broadly. And then we wind up having basically laws that say do good stuff for the environment, and the good stuff will vary between who is actually president, who are really making, in some sense, actually making the law. The real law, not just the general principles involved. So I think we have a big chicken and egg problem, which is the more we allow the executive to do this stuff, the more incentive Congress or the state legislatures or city councils, for that matter, have to defer. But I don't know how you make, other than being a public uprising like see, or having some stronger non-delegation principle, which wouldn't work very well in emergencies. I'm not sure what to do. As for John's question about redistribution, so people wonder why, how the Republicans did reasonably well this election, given the sort of bizarre behavior of the commander in chief, and the fact the economy was in the toilet, which usually isn't a good sign, and everything else. And there are a few, you could ask political scientists, but I think one reason is that there were a lot of people around the country who got a sense that, intentionally or not, we have a form of class warfare going on implicitly with how we've reacted to the virus, right? That those of us who have these white collar jobs, right? I mean, my life didn't really, I caught COVID, so that was bad. I was in the hospital, so that was bad. But putting that aside, aside, I teach from home. It's actually a little bit more, it's not as good for the students, but it's a little bit more convenient for me. I still get my full paycheck. I don't have commuting costs. I don't have to wear a jacket and tie. I've been doing great in economically and professionally. There are all these people who've been losing their jobs in blue collar fields. You have the situation where we've closed all sorts of small businesses. But Walmart is essential, so they sell everything. So the local shoe store can't be open, but Walmart, because they also sell toilet paper, is allowed to sell shoes, and so forth and so on. And the reaction that I've seen from a lot of sort of pundits who are supportive of the way the lockdowns have gone is like, well, we could just compensate those people, and what's the big deal? Well, first of all, if you lose your job somewhere you've worked for a long time, it's not always that easy. Even if you can find a job eventually or get a paycheck from the government, you develop relationships with your coworkers and your customers. It's not so easy. But also the small business owners. I mean, it's so obvious to me that a lot of people who've never owned a business simply don't understand that, if I built a business for 25 years and I get $80,000 of income, merely writing me a check for $80,000 this year, but telling me my business is gone forever really doesn't compensate me. I put my blood, sweat, and tears into this particular business. I built it, and there's definitely been a sense that the mayors and governors, that the coalitions they've represented have not really assimilated that at all. So I'm not sure what exactly to do about that, except again, judges should be careful about looking at whether these things are arbitrary. But to John Witt's point about the fact that when there's these sorts of emergency decrees, the rich and powerful do better than the poor and unpowerful. I mean, that's one of the reasons I'm sort of libertarian. I mean, duh, who's going to do better in the political context? People with money and power, people without money and power. Some people seem to think if we just assert that somehow that's going to stop happening. But in reality, there's something sort of inherent in politics that people with power do well when power is exercised, right? So I don't see any easy way around that, except again, judges trying to. People mention it, so it doesn't hurt to point out that you're hurting certain people, and judges can certainly be alert to it. But the idea that somehow just by wishing that problem away, it's going to go away doesn't strike me as plausible.
Thanks, David. Ilan?
Just briefly on the favoritism point, since David covered it so well and others, I mean, just from my own experience here in Arizona litigating our case, it's a little bit of both, I think, and I don't think it's particularly nefarious. I mean, I don't think it's like pay to play or any sort of corruption. It's not that. It's just if you overreact, and lots of people are going to suffer as a result of the choices. Obviously they might have suffered anyway because of the pandemic or whatever, but certain people are going to suffer. And then people come knocking on your door if you're the governor, saying, oh no, you're going to crush us, you're going to kill our businesses. And then they start making exceptions and narrowing things. And who are the people knocking on the door? The people with political power. So is that favoritism? Is it overreaction? I mean, it's a bit of both. I don't think it's particularly nefarious or corrupt or pay to play or anything like that. It's just how politics works. And that's the danger of giving such broad power, at least when you have at least when you have state legislatures making the choices. The rational basis test can be justified on the theory that, again, the representative debate, it's an institution. They represent different parts of the community. They're closer to the ground than maybe governors are or other executives. And, maybe the rational basis test is justified there. On Dan's excellent point on municipal corporations versus governor, that's certainly true. And I think that would be relevant in some areas of law, like maybe, I suspect, delegation of legislative power downward vertically is okay, like to municipal corporations, to territorial governments, because they're there's this vertical control, and it might make it less okay to delegate horizontally to an independent executive. But for purposes of this rational basis test, I don't know why that would be the case. To the extent the executive is independently exercising independent executive prerogatives, there's nothing, I don't think the state legislature can't stop it. I don't think the court can stop it unless there's some independent basis. But to the extent they're just exercising delegated power, it's an empty vessel. They have to do what the legislature asks of them. And I don't think they're, in that respect, any different than a municipal corporation. But it's something I will have to think more about.
Okay, thank you. We have some time left, fortunately, for audience questions. And if I understand it correctly from what the Federalist Society's excellent technical people have explained to me, if you're in the audience, you should have a hand raise function, which should make it possible to indicate that you'd like to ask a question. I should see that, yes. in the, and I object to this word, attendees category, which I'm looking at now. And then the Federalist Society people should be able to demute you to get your question. And the first one here is Kevin Douglas.
Hi, folks. I have a follow-up question for David, and I'm happy to get a response from everyone on the panel. David said, I think jokingly brought up the idea of having a revolt as the way of solving the problem of legislatures passing laws that say do good things, and then simply having, lawmakers decide for themselves, executives decide for themselves what's good. What do you think about the nonviolent solution of getting voters to think about what kind of good standard of good or bad they want enforced by law, and then passing a constitutional amendment to try and focus and narrow what conceptions of good, justice, or fairness can actually be used when lawmakers decide they want to try and have an open-ended kind of grant of authority given. And same thing if for other possible conceptions like social welfare. What do you think about having a constitutional amendment that clarifies which of the competing notions of it are going to be enforced by law?
The only example I can think of offhand that really goes to that would be the way Congress has tried to get at least some agencies to engage in a cost-benefit analysis, which is a way of getting to what the good is, right? That whatever you do, here's figure out how to measure costs, figure out how to measure benefits economically, and don't do economic regulations that cost more than they're worth. You would think that would be a relatively uncontroversial proposition in the abstract, but in practice, this is extremely controversial. I mean, even people on the left didn't want Cass Sunstein in the government because he actually to be in charge of some of this stuff because they thought he was too utilitarian. After all, how do you put a price on the beautiful view of the Grand Canyon, that sort of thing? So some of the people here who do more administrative law than I do might have other ideas, but Congress certainly is capable of giving, even if they don't give specifics about particular legislation, and state legislatures too, could give more guidance as to what criteria should be used when making these rules. And that may not be as inconsistent with Congress's desire to avoid responsibility for the outcomes as them actually giving detailed proposals.
And if anybody else on the panel has a thought on that question, please. Okay, in that case, the next question is Josh Kleinfeld. It looks like you're muted. So you may need to, there.
Read out, can you hear me now?
Yep.
Yes.
All right, apologies, folks. My question was this, I wrote it down, I'll just read it out. Are there any states or localities in which legislatures have played a substantial role in deciding upon the scope of the lockdown or deciding how to balance the various trade-offs involved in controlling the pandemic or otherwise setting COVID policy? My sense is that apart from congressional bailouts, no legislature at any level of government played a significant role in responding to the pandemic, except insofar as they set up relevant agencies before the pandemic. The structure of government in this area over the last year has been one of president, governors, mayors, agencies, and judges. They're the players, and the legislatures and legislative tight bodies at the city level just haven't had any role to play or haven't wished to play any role. And my question is just a descriptive one. Is that factually true? I guess I'm interested in your normative thoughts on it. True as well, but just descriptively, have I got that right?
So I think that I'll take a stab at that. Yes, is the one-word answer. I think you have that right. I'll smuggle in not subtly my normative view, which is when they've gotten involved, they've almost always gotten involved to screw things up, which is to say they've gotten involved to speak to restrain gubernatorial power without. Let me give a practical example. Let me be less obnoxious, snarky about it. So, ironically, conservative legislatures in a number of states have been seeking to pass legislation. We haven't talked about this yet on the panel yet, to limit the ability of private businesses to require so-called immunity passports. That is, private businesses to require evidence of vaccination or evidence of presence of antibodies as a condition for returning to work. say ironically, right? This should be something they should leave to the discretion of private businesses, but they've attempted to pass legislation. I think in some states they'll be successful in passing legislation forbidding private schools or private businesses from imposing these requirements as a condition to come to work. And they've done so in the mantle of, oh, it's virtue signaling on the part of businesses, and we want to strike a blow for liberty and let's get people back to work and blah, blah, blah. So it strikes me as the legislature, and I think this was tacit in your question, Josh, not only have not been profiles in courage, but to the extent they've been involved in a way that hasn't helped us in reducing the impact of the pandemic from a public health perspective, or provided really much sustenance to individuals who were truly suffering.
So
anybody else? I
IMHO.
think this is a really important question. Julia, please.
I have a slightly more optimistic take, I think. My response to your question is yes, and. I think descriptively you're correct. The legislatures have not played a major role, except, as you point out, Congress and its huge financial relief packages, which may not, as we've been discussing, be directing financial relief to those who most need financial relief. I do think that a lot of state legislatures, though, have been monitoring very carefully. There were certainly rumors in Virginia that the General Assembly might do something if it didn't like the way that the governor was undertaking the COVID-19 response. And I've heard similar things in other states. So I think that it's that one reason perhaps we haven't seen more obvious actions by state legislatures is that governors were consulting with them on a quiet basis and were careful not to do much that would incite a legislative response.
David or Ilan, because I have another question about this, but first, if either of you have any thoughts on that. David, please.
So this allows me to rant about one of the things that is just driving me crazy, which is that we actually have something of a coalition of the left and the right that is resisting legally, socially, otherwise, the idea that people who have been vaccinated, or importantly, as in my case, have had COVID and recovered and can prove it, from being able to do things that other people are restricted. Now in Israel, they're giving people 6-month green passports, they call it, where if you've been vaccinated or you can show that from your medical records, which are centralized there, you have had COVID and recovered for 6 months, you're allowed to do all the things that you're not allowed to do under their various lockdown provisions. In my case, I can't do it. I have to go around wearing my mask. That's fine, whatever, solidarity. People won't know when I'm wearing it. But things like, all these small businesses, all these restaurants that are closed. Does it make sense to say that, hey, if you've been vaccinated, which a lot of people will be soon, or you've already had COVID, you can't go to the restaurant unless you eat outdoors? Why not? And the answer is, on the right, they say, oh, well, it's all a hoax, or more or less obnoxiously or crazily, I don't want to get the vaccine. It's all exaggerated. It's not worse than the flu. And why should I have to do that? And then on the left, I keep seeing op-eds and blog posts saying it would be discriminatory to, it's unegalitarian to say some people should be allowed. And God forbid there's some moron out there who decides that they're going to get COVID so they can have a green passport. Oh, that would be terrible. If someone, we have to protect people from their own stupidity. So if we gave out green passports, some people would do stupid things to get one. I don't think we should be making public policy based on the notion that everyone in the country is a moron and can't follow proper directions. I can give you other examples, which I won't, about how that's playing out in the COVID crisis. But I really do think that legislatures or somebody should step in and do something akin to what they've done in Israel. And one way of helping to open up the country would be to say, hey, if there's a 99+% chance you're immune, you're a good person to allow to go to school, go to a restaurant, and do whatever.
Ilan, any thoughts?
Yeah, I guess the only thing I'll add is, two things. One is the reason that state legislatures haven't been getting involved is precisely for the reason David mentioned earlier, which is it's just public choice theory 101. They don't want to. Right? This is why delegations happen. They get credit on the front end for passing great legislation to take care of clean air and to solve emergencies and protect the public health. And then when it comes to actually making the tough choices, they can go back to their constituents on the back end and say, oh, I didn't intend that, so I'll lobby the agency or the executive or whatever. I mean, it's a win-win, generally speaking, for the legislatures, so they don't want to get involved, and it's in their interest to delegate power. And the fact that the state legislatures haven't taken action, I don't think should answer the question of whether it's their power or duty, or it's or whether they've in fact impermissibly delegated legislative power. And the other thing I'll just say is there's no reason state legislatures can't take action. There's no, I have, Dan's absolutely right that state legislatures do stupid things when they get involved or have gotten involved, but many governors have done really stupid things, right? And so there's no reason the state legislature can't take a more active role. There's no reason that, if the Arizona Department of Health Services can establish guidelines for businesses reopening, there's no reason the state legislature can't consider it. And this just goes back to administrative law principles too. You can take advice from agencies. They can help you formulate, legislation. We can even do like a REINS Act type thing at the state level, where if you regulate private conduct and behavior, the legislature has to approve it first. There are all sorts of ways to get the legislature more involved without worrying about expertise and speed and rapidity and things like that. So, I think we should give them more of a chance.
Okay, I'm going to call on Eric Asmussen in just a moment, but I have first, I want to say that Chris Green in the chat has pointed out to us that the Oxford, Mississippi City Council, I guess it's the City Council, has actually been doing things, has been legislating on lockdowns and how it should work and so forth. So, because that's one thing I was wondering about, was maybe some of the local governments have been more active and more flexible than some of the state governments. And a question I'll ask, if there's anybody on the panel who knows something about this, is it possible that in some of the smaller and middle-sized states, one of the explanations for legislature inactivity is the way their calendar operates? That is, if they come into session at the beginning of the year, aren't set up to sit continuously the way California and Congress do, and a serious problem comes along in March and April, is it possible that just institutionally that's going to be hard for a legislature to find out what's going on and spin up on and operate its process?
So the short answer is structurally, yes. The answer is clearly yes, John. Texas and other states have limited sessions. Practically speaking, you're also quite correct. The gear up to do anything substantial would seem to be a heavy lift. It should also be said, though, that even among those states that have very limited sessions, the opportunity for special sessions exists and persists in state constitution. So it's debilitating for reasons you've said, but it may not be absolutely prohibited.
Thanks, Dan. I'm going to ask Eric Rasmussen to demute and,
okay, am I demuted? I like demute. That's better than unmute.
Yeah.
Well, I think Ilan put it very well. It's an open question as to who are the greater fools, the legislators or the governors. And I'd enter the judges into the competition too there also. But we have a system where we have separation of powers. And what would make me happy is just if the legislatures would ratify whatever the governor did. Put it up for a vote. You can do that in 3 days. If they really approve, they can say so. But as Ilan also said, they don't want to do that because they don't want to bear any responsibility. They're just passing the buck. But if we made them do that, I can't see any argument against it. It wouldn't have to delay things, even with legislature calendars, if they're given 3 months to do it, say, or 6 months. So how can we allow the governors to do this for such an extended period of time? And
I'll take it.
Ilan, please.
Yeah, I'll take a stab at that. Just Arizona is such an interesting example because we have an emergency powers statute that provides for a declaration of war emergency and declaration of other emergencies. And under a declaration of war emergency, the governor has to call the legislature into special session within 24 hours. And the question is, why do we think he has to do that here? And that's because I think a war emergency can be expected to last sort of a long period of time, whereas the other typical emergencies, under our statutes, right? Fires, floods, earthquakes, things like that. It's like they just happen quickly, and the legislature is not going to complain because it's going to be over and done with, right? And pandemics, some will be quick too if they're exceedingly deadly, and then I promise you, no one is going to raise a complaint because we either won't be around or we won't need to be told. Right. But when it comes to a pandemic like this, that's very deadly for a segment of the population and less deadly for others, where there is room for there's people are going to disagree over the policy response to it. And it goes on for a long period of time. There's no reason the legislature can't get involved for that kind of emergency. And maybe the answer is these states just have to amend their statutes to say something like, if the emergency conditions persist for more than a month, assuming the legislature can safely convene, they should be forced to convene, right? Look, if a fire has raged through the Capitol building, well, even then they could beat somewhere else. You know, as John said, we have that statute at the federal level, right? They could convene somewhere else. But like, look, if as long as the legislators are alive and willing and able, rather, I should say, not willing, that doesn't matter, and whether they're able to meet after a certain period of time, they should be forced to, and that's just a matter of amending the statutes, I think.
Anybody else? Eugene, we'll get to you in just a moment. I want to pick up on this and ask, and this is again, if anybody happens to know anything about this, whether in any state legislatures it looks like there's going to be maybe some productive lessons learned activity and perhaps changes to the permanent emergency legislation, because this is a great opportunity to learn about a kind of emergency that doesn't come and go like an earthquake or a wildfire, but lasts for months and months and months. Anybody know anything about that?
I know a little bit only because, again, in my experience in Arizona, there's already a joint committee of the state and House at which I've testified, you know, about how to amend this in the future. And there were, not surprisingly, a lot of disagreement among the legislators who were all, by the way, very, very smart. And so state legislators get a bad rap a lot, and people would rather the governors do things, but they were extremely intelligent. And so I know Arizona, for one, is already looking at this, and I would expect other states as well. Probably more where there is more Republicans, but it's hard to say.
Dan, it looked like you demuted. Did you have, and then Julia?
No, please, Julia.
Okay, Julia.
So I wanted to ask Ilan, what are the major sources of disagreement amongst the state legislature?
The same that you'd expect, like among the public, that some think it's just okay to give the governor, you know, the kind of power. Though it's odd, of course, because when you agree with what the governor is doing, then you tend to not have any problem with giving the governor power. But of course, someday the shoe's going to be on the other foot, and it's going to be a governor of a different party. You know, in Arizona, it's a bit weird because we have a Republican governor, but the Republicans really dislike him right now. And so it was the Republicans who were much more in favor of reining in executive power. And it was the Democrats who were like, no, the governor's been not doing enough, give him more power, you know, and he should exercise it, right? So that's how it broke down at our committee here.
Okay, Eugene Kontorovich, if you could demute and.
Okay,
Yeah,
so
we got
not to anticipate too much my works in progress presentation in 45 minutes, but Julia noted, I think an important point, that there's a huge amount of litigation about COVID closure orders, but they tend to be not around the central thrust of the lockdowns, which is clearly economic and you know, in the business closure department, but around particular rights like prayer, also abortion, Second Amendment cases. And Dan suggested that may be, you know, the only thing available because of Lochner and its conclusion. So I would wonder whether you know, how sure we could be that Lochner precludes challenges to business closures, given that every single case that is being heard about COVID today is being decided under a jurisprudential rubric, which is essentially a Lochner era rubric. That is to say, Jacobson. So Jacobson is the first case every court's going to discuss today, and Jacobson is a Lochner case. That is to say, it was decided actually 2 months before Lochner, and the argument of the Jacobson's argument sounds in what we would call today substantive due process, unenumerated rights. And thus the entire analysis of Jacobson, which as Dan as Dan points out, is not a carte blanche analysis, is quite deferential, but not carte blanche, is fundamentally nestled in a worldview or in a universe of substantive due process and unenumerated rights, which, to be even more specific, maybe in Jacobson could be seen as economic rights, because the Massachusetts vaccination statute did not actually require compulsory vaccination, as far as most people can tell. That is to say, nobody was actually physically coerced. Rather, it was like a fine or a penalty for non-vaccination, which is all Jacobson would have been facing. He had about $5 on the line.
Julia, please.
So this is the question, or the set of questions. My own view is that there's an enormous amount of indeterminacy here in terms of what the law is and where we are with constitutional doctrine. I think the so-called New Deal settlement, whereby police powers, which is often described as the police powers are without limit, and if you want for any court to find limits on what government can do, you have to figure out how to shoehorn, my word, your claim into First Amendment, Second Amendment, et cetera, a right of privacy and so forth. I think that is exaggerated. I think that it is possible, although it will be difficult for those who are bringing court challenges to get some success, maybe by arguing that there are limits on the police power. But as we've been discussing during this panel, being able to point to a First Amendment claim is the quickest road to success. Second Amendment rights of privacy and so on are also good routes to success. And arguing that the government simply doesn't have the power is usually the least promising. I think it is possible that what we've seen with COVID-19 may, I do stress may, push constitutional doctrine a bit more in the direction of clever litigators being willing to shape economic and other basic liberty claims without the need for a First Amendment or other hook. But as you can tell, this is an area that interests me enormously, and I'm watching it very carefully. So I'd like to hear what others on the panel and others in the audience that are thinking along these lines too.
So I know if we talked long enough that Julia and I would reach complete agreement. so I think we have on this. But I actually want to harken back to something that David Bernstein said in his presentation that I think, because Eugene, I think your idea there is quite shrewd. I would cabin it a bit. I would say the optimism is mostly going to be optimism at the state constitutional level. I don't think it's going to be a reformulation of, Williamson v. Lee Optical and et cetera, et cetera. I think it's going to be more, and there's some pockets of optimism in, the post-Kelo world and other state ones. But what David said, I think is really right. Courts might actually be moved by the predicament faced by small business owners and individuals. It's not just the business owners, it's their employees. The ruination of our nation's restaurants, well, maybe that's a little bit hyperbolic, but the enormous crushing economic burden on the restaurant industry and bars and the like has revealed everything that we could worry about: economic meltdown, disproportionate impact. The ruination of restaurants is basically ruination of work opportunities for Latinx individuals and many others who populate our industries. So I think there's an economic liberties angle here that can be quite powerful as long as the pandemic persists, and maybe, just maybe, reinvent kind of the locus of constitutional attention. And I think that wouldn't be a bad thing. I think it'd actually be a good thing. Although I would be nervous about how capable the state courts are in adjudicating these kinds of claims.
Ilan or David, anything on this one? Ilan?
Yeah. I mean, the only thing I'd say is there are so many ways to get at judicial review of these government, actions without having to revive economic substantive due process. Look, economic substantive due process didn't make sense. It didn't make sense. Lochner was wrong. Why was it wrong? Because when a state legislature decides something, absent a specific constitutional prohibition, look, okay, if it's discriminating, if it's violating the Privileges or Immunities Clause or the Equal Protection Clause, which historically didn't mean what we all today think it meant, but right, so absent an express constitutional prohibition, when there's nothing written limiting the legislature, who says the courts would be better at figuring that out than the legislature, right? But we don't have that here. As we just discussed in response to Josh Kleinfeld's question, the legislatures haven't gotten involved. It's a single governor, right? A single person making these decisions for an entire state, sometimes a state of 50-some million people or some million people, or state of several million people. In that case, I perfectly feel comfortable saying courts should, be more, should be less solicitous of what the governors are doing, because it's not a state legislature. A state legislature debates, represents multiple parts of the community, and they move a bit slower. When the executive acts, it's a single person of a single political party. And why should they be trusted to know, what's in the best what's in the best interest of the people's welfare in every single case? They're much more likely to be amenable, to protectionism and favoritism and things like that, because again, they're a single person. There's no checks and balances. There's no separation of powers when it's just them acting alone. So I'm perfectly okay letting courts review their acts like they review the acts of municipal corporations. That doesn't mean it's substantive due process. I think it's something else.
David, do you have any thoughts on this one? Okay.
Sure. I think that, Dan's point about state courts being the font of this stuff is something that I've thought about. I wrote a piece for the Yale Law Journal online, whatever it's called, a few years ago about the right to pursue an occupation, which seems to be getting some play both politically in terms of licensing laws and whatnot from both the Obama administration and from people on the right, and is also getting some play in state courts. And the thing about that is that it doesn't require you to go full-fledged into economic liberties or right to contract. It's a very specific right to pursue an occupation, and it's been widely recognized by both sides of the aisle, really, that again, your job, your career, your business is part of your identity. It's not simply, like rate regulation or some other Lochner era controversies where just, who really cares whether, other than the shareholders, who cares what rate of return the local electric utility gets? It doesn't go to anyone's fundamental identity. So I think this could bubble up through states, and I think it will come more from states than from the Supreme Court. The Supreme Court, frankly, is, in my view, the people on the right are terrified that anything that remotely resembles substantive due process will somehow give aid and comfort to defenders of Roe v. Wade, and therefore they stay away from it. But again, there is this big tension here, which is that if you do, as the conservatives have done, block any recognition of new suspect classes for over 40 years, and you refuse to recognize any new fundamental rights and try to limit those that exist, at some point novel things are going to come up that the existing categories don't cover. So what happens when a governor arbitrarily keeps businesses closed, destroying livelihoods, and businesses that people work decades of their lives to do? Is there nothing that can be done? Well, state courts have somewhat more flexibility. They have their state constitutions. They could sort of play around with Supreme Court precedent a little bit more without worrying about the effects on Roe v. Wade. So we'll see. I wouldn't say I'm optimistic, but a lot like Julia, I think, and Dan, I think there's at least some possibility that this will lead to some judges to reconsider where we stand and whether we have a too limited form of doctrine here to deal with the various sorts of things that come up.
Okay, Kevin Douglas.
Hello again. Let me know if you can hear me fine.
You're good.
Thank you. I'd like to get the thoughts of Julia and Ilan to a proposal that I think addresses concerns raised by each of them. I think Julia brought up the idea of wanting a better way to rein in executive power when it seems like there's executive overreach. And Ilan brought up the idea of basically legislatures seem to have the messed up incentives of wanting to get credit for passing laws that are attractive, but wanting to avoid responsibility for actually making sure any laws are useful or good, and therefore, passing these vague statutes. Is there any viability of not necessarily suing the executive for overreaching, but suing the legislature for underperforming? I know that people only use the idea that most government officials are fiduciaries in the loosest sense, or when they want to prosecute them for insider trading. But I would think that there's the possibility of an analogy to duty of care litigation, where you say, you guys have a job, you haven't done the job, and we can point out at least some bare minimum standard of what you're expected to do in certain kinds of situations. And clearly you didn't do it here. When it comes to the pandemic, you need to figure out X, Y, Z, and you didn't do that. And one example might be something to the effect of, in Michigan, the state has a statute, the emergency statute in Michigan says that the executive essentially has 28 days to do whatever the heck it is they want before they have to call the legislature to authorize them to continue putting in place whatever emergency thing they did. The executive goes past the 28 days. The legislature doesn't do anything to stop them. The people come along and stop them, but couldn't you say that, legislature, the fact that you didn't step up to try and rein in the executive and try and get them to ask you permission, maybe that's an abnegation of duty, something to that effect?
Let's try Julia, then Ilan, and then if Dan or David has anything on this one. So Julia?
Well, it's a fascinating question. I would separate the question into two different, two parts, though. The first is it possible that a court might be willing to declare such a thing? Maybe. The second, though, is would a court be willing to craft a remedy and then purport to have the authority to order another branch of the government to do something, particularly in a pandemic/emergency situation? That, I think, is way, way, way less likely. So to the extent that your idea would, I think, get off the ground, it would be in persuading courts to make some kind of declaration. But as you know, courts will often not do that, particularly if they don't think that they can harness their declaration, that they can accompany their declaration with a reasonable remedy.
Ilan?
Yeah, I mean, I would just echo what Julia says, and there's just a lot of risk in doing that too. I mean, if courts can start compelling legislatures, to do their, do what the court sees as the legislature's duty, I mean, the whole point is it's the legislature's duty. I don't know. It's like, do they force them to fund schools? Can the courts raise taxes? Like, how do the courts raise taxes? And then there's this other side of it, which is, part of not legislating, right, could be the exercising your duty as well, right? In the sense of, the commerce power historically, why was it understood to be exclusive, or why was it thought to be exclusive? Because it was understood to be a comprehensive power. When you choose, the legislature, Congress chose not to regulate commerce, that was a judgment call, that trade should be free. People should be free. People should be free of restraint, to do whatever. And so when a legislature doesn't take action, that could be a judgment call too, right? Which is what makes it very difficult. So I think the only way you do it is through a traditional lawsuit with standing, usually against the enforcers of a particular law against you. And then, delegation can be invalidated that way. And the corollary of that is maybe the legislature has to get into session to do it, but it doesn't have to. It doesn't have to, right? It just means the executive can't do it. It doesn't mean the legislature has to take action. It just means the executive can't take action. And if someone wants to take action, it has to be the legislature, but you don't compel them otherwise. I mean, I think that's the best I got on that one.
David?
Yeah, so Kevin gave me the idea that I don't know that any judge will actually do this, but one thing I might consider if I were a judge under these circumstances, and I was suspected that strongly that some of the measures the governor's undertaken that may have been already 8 or 9 months old, I may not have been that well thought out, I might very well say, well, look, I'm going to allow this to continue for 30 days, 60 days, whatever seems reasonable given the state of the legislature. And if the legislature endorses it in that time and passes legislation signed by the governor, then I'll just assume that I'm not the one to judge in an emergency what the right trade-off is. But given that the governor's power here is not completely legitimate to begin with, it's only supposed to be an emergency power, and we've gone on for almost a year already with this, if the legislature is not going to endorse it, and I don't think this makes any sense, I'm just going to go with that.
Dan?
I think standing. I'll just say standing. That's my one-word answer. Question mark.
A good question. All right, we have a
Thank you, Walt. That was great.
Left. So if anybody has any last thought, otherwise I'll just wrap it up. But I don't want to. Dan?
Can I have 45 seconds?
Please.
John, none of us responded to your good question about federalism. And I just wanted to offer this. I think I'm not sure I have a great wisdom on offer, but this debate that's been properly focused on state authority and all of that elides the question of whether we've learned anything with respect to federalism. It's tempting and easy to say, oh, the dearth of federal authority, the absence, nature abhors a vacuum, and all of that. But when you asked a different question, which is whether or not states are engaged in legislative reform efforts and really rethinking of this, I think what states need to think about, and Congress too needs to think about, is the characteristic of a pandemic is it knows no boundaries and borders. And so given everything that we know about about laboratories of experimentation, the good, bad, and the ugly, and congressional gridlock, we really need some approaches that introduce a much better species of collaboration and mechanisms and modalities of collaboration among the states and among the states and the federal government if we're going to ever confront the last months of the pandemic, to say nothing of other public health emergencies like this.
Anybody else?
Yes.
Julia?
Like Dan, I wanted to get back to your excellent question about federalism too. And I want to ask you, well, what do you think after the recent spate of decisions by the Supreme Court, particularly about the Commerce Clause? The conventional wisdom, as I was taught it at the Yale Law School, and maybe you were too, that now that we're in the 20th century, that was what was said anyway, that they brought enumerated powers, including interstate commerce regulation, so on, gave the federal government sweeping authority that would include virtually all questions of public health. Well, that conventional wisdom doesn't seem quite right in 2020, but how would you modify it?
Well, I have a brilliant proof on this, but it will not fit into the remaining 30 seconds that we have for this panel. I want to thank all the participants, thank everybody who attended, and the Federalist Society has asked me to tell everybody who's watching or listening, as it were, you don't have to go home, but you can't stay here. That is to say, this webinar will not continue into the next session. So you need to sign up and get on the next one, which I guess is at 4:15, the 7-minute participants. And other than that, I want to thank everybody. And we're done.